So estate planning is the process that if you didn't have the ability to make your wishes known, whether you were sick or if you had passed away, it's your legal wishes in writing. This is a comprehensive estate plan that's not just made up of one document, but several documents where each one has very specific things that they do. All of these documents together make a comprehensive estate plan. It is extremely important that you have an estate plan in place for your family. Without having an estate plan in place, it means that if something were to happen to you, if there was a car accident, if you had a stroke, if you developed Parkinson's or Alzheimer's, that your family would have no ability to make medical decisions for you on your behalf or be able to make financial decisions for you on your behalf. It also allows you to say that if something were to happen to you, how do you want your assets to be taken care of if you were sick, to be able to pay your bills, to pay your mortgage, to pay medical bills, nursing care, or if you were to pass away, how you would want those assets distributed. This is why estate planning is crucial, and it is important for every single person to have an estate plan of some sort. The difference between a will and a trust is pretty confusing. When it comes to California law, a will is a document where you give specific instructions to be carried out at your passing. So a will actually only comes into play when you pass away. It is a public record that gets filed with the probate court, and thereby anybody can understand who your beneficiaries are, what assets you own, and who your creditors are. A trust, on the other hand, also known as a revocable living trust, is an agreement. This is a private agreement between you as the creator of the trust, where you have specific instructions in writing, where you say, if something happened to me, whether I got sick or I passed away, this is how I want my assets to be cared for. A trust, again, is private, so it's kept out of probate court. Without having a trust, a will alone will not avoid probate court. If you have minor children, then you need to ensure that they are cared for in your estate plan. The reason for this is that children under the age of 18 in the state of California cannot actually inherit money or property, which means if you have them listed as a beneficiary on your life insurance policy, retirement accounts, maybe they're on grandparents' retirement accounts or life insurance, they can't actually inherit that money. And so it would have to go through the court system where then they would get access to all of that money when they turn 18 years old. However, if you have a trust, a revocable living trust, a living trust, all the same thing, but one of those documents will allow you to say, if something happened to me, I can have my life insurance policy go into my trust to be cared for my children, and it can be given to them when they need it or ages that you set, maybe 25, 30, 35. So this will make sure that those assets are protected for the benefit of your kids, keeping them protected from creditors, predators, divorce, future spouses, future ex-spouses. And it's important that it is cared for specifically in your trust. So when it comes to estate planning, if somebody has been diagnosed with something, something that's coming on very quickly, this is a crisis situation where families are going to do what is necessary to get legal documents in place. It is important as soon as possible to try and get some type of legal plans in place. It is the saddest situation to see families when somebody is literally dying in a hospital bed and we have to visit them to try and make their wishes legally in writing at that point. So if you're at this point where you are in crisis planning mode, at the very beginning, as best you can, try and get something done. Because when you're at that point, you don't want to be thinking about this. You need to be thinking about it before it actually gets to this. Well, when it comes to creating estate planning documents, if somebody is in crisis planning mode, meaning they may not have the ability to make decisions for themselves, there's not really much that we can do from an estate planning perspective. That's where we will need generally court intervention. So from a crisis planning perspective, we want to make sure that the person that is going to be signing the documents has the legal understanding. They have the capacity to know the documents that they are signing to be able to make sure that their wishes are known exactly how they want them.